meet you. Yeah, you too. Yeah, feel free to pop whenever they will be coming in until the last I mentioned.
Just who I am.
Yeah, cool. Hey, do you take reports at the moment?
I'm not at the moment. I'm in criminal part.
Oh, nice.
I'm in part 2.
Yeah.
Still settling in.
Yeah, nice. How's it all going?
Yeah, good.
Yeah.
If you think I'll be enjoying courts and contracts more than I enjoy criminal part. But
Oh, yeah?
yeah. I'm just more of a liability person than I am about criminal.
Yes. Okay.
They can take this on the side.
Yeah, well, exactly. And then you get to pursue what really interests you. So.
Take my strange niche courses.
Yeah.
I want to take like tax.
Oh, yeah. Yeah, well, the tax lectures here are and it's really interesting tax. I actually started off my career as a tax lawyer at W10L2. Now I'm here.
But yeah, I don't particularly love math, but
Yeah.
like, if I can use a calculator, it's okay.
And tax isn't really about maths, it's more about strategy and transaction.
But yeah, it will be interesting. Very much to get into the nitty gritty of things. Yeah, not a very generalized person.
Yeah.
But
Yeah. Yeah.
it's a lot less people than me from yesterday.
Oh, really? Ah, interesting. I don't know why this is the case. Because we just have one stream as well. But maybe by the time they're in third year, sometimes
But also there's a pretty big drop off rate between part 2 and 2.5.
Oh, is that right?
Yeah.
Oh, in terms of students not carrying on. Oh, interesting.
I mean, like I know quite a few, about at least 10 people.
Yeah, who are going to school? Yeah. Oh, no, interesting. So they just have to enjoy it.
I think, yeah, that. So I just think that the content in some of the lectures are not more expected.
Right.
Like it's a bit more intense.
Oh, right.
That's not to necessarily say it's bad news. It's not what everybody is expecting to go into it.
Yeah, when they sign up to it, it's a bit different. I'll just get their attention and then you can. Okay, hi everybody. Just before we kick off today, Shay Hardy just has something to talk to you about.
Thank you. Hi everybody. I hope you're all having a good morning. It's very early in the morning, but hello. For those of you that don't know me, my name is Shay. I'm a Part 2 law student here at UOA, just like you guys, and I'm running for the University of Auckland Student Council representative position. I'm here to pretty much just get my name out and say hi to everybody so that you can kind of put a face to all the like 50 million names you got in your inbox yesterday. But if you can, I really encourage you to vote, even if you don't necessarily want to vote for me. Just make sure that you are getting your votes in, because it is super important that everyone gets to have an opinion on this, and it is super important that everybody gets to have their say. There is a debate today also at midday just on the engineering terrace. If you're curious or you have any questions or you just want to come say hi. But yeah, that's everything from me.
So, thank you.
Thank you.
Have a good day. Okay, so, yesterday we went through, we're looking at this broad picture of liability. Remember, we're looking at the difference between act and omissions, and what are the legally significant features of cases where courts will impose a duty of care in relation to omissions. Okay, and we've looked at this first section. We're not normally liable for a danger we have not created unless special circumstances exist. Those special circumstances are when the defendant has assumed responsibility by taking on a task. Remember that the assumption of responsibility in this context is a bit different to the assumption of responsibility in the context of a negligent misstatement. Sorry, I can get both. Do you like both up, or is one? Yeah, both is good. So it's a bit different from taking on the assumption of responsibility in a negligent misstatement. The position of reliance is not as essential. It is a bit more case specific. We've seen cases where reliance has not been necessary. For example, Barrett, where the serviceman was unconscious and not in a position to rely. Equally, in Kent, the fact that the doctor would have otherwise told the patient's husband to drive her to the hospital. They relied on the ambulance getting there immediately as they were told. It had been immediately dispatched. Reliance did seem to be relevant in that case. So the position is reliance is a bit of a grey area, an assumption of responsibility in the context of an omission. The second exception we talked about was when the defendant has a position of responsibility, and we talked about things like being a landowner or occupier of land, an employer, etc. And we finished yesterday talking about the situation where a defendant is in a position of control over the cause of the danger, and there is reasonable foreseeability of harm caused by that danger, and essentially a particular risk of harm to the particular plaintiff. And the case we talked about there was Home Office in Dorset. Now we're going to move on to situations. Now, equally, just before we carry on, in these situations, the first set we talked about, this also captures cases where the immediate wrongdoer is a third party, okay? So when the defendant had assumed responsibility by taking on a task for the claimant's welfare, we talked about Stansby and Troman, where they had assumed responsibility to lock up the house when they left. They didn't lock up the house. A third party came and stole a diamond necklace. The decorator was liable for the acts of that third party. Okay, and in the position of control, obviously it was the Borstal boys who were the immediate wrongdoer, but the Home Office, who had responsibility for the custody of these Borstal boys, was liable for the damage those Borstal boys caused. So now we're moving on to this highlighted section. We are likely liable for a danger we have created, including a danger resulting from human agency where it's foreseeable that third parties may spark it off. Now, the first thing I'm going to say about this is that Home Office in Dorset, which is the case we finished off with yesterday, has more recently been rationalised on the basis of creation of the danger. Okay, now Lord Diplock's reasoning in the case that we closely focused on yesterday was all about these two elements of control of the third-party wrongdoer and particular proximity with the plaintiff who suffered loss. And we'll see how that's been applied in New Zealand when we move on to public bodies. It is authority for this position, for the exception of control and particular proximity. But in more recent cases, they look back at that and say, actually, we could rationalise that case on the basis that the Home Office created the danger. They created the danger by bringing the Borstal boys to Brownsea Island and not supervising them properly. And it was foreseeable that if they didn't supervise them properly, this is a danger which they then sparked off by stealing the boats and crashing into other boats, etc. And it's kind of interesting, sometimes the same outcome for a duty can be rationalised on different grounds. And I just want to mention that because if you read the cases, you will see them talk about this being able to be Home Office in Dorset being able to be rationalised on this alternative basis. That's a more modern review, kind of a contemporary retelling of that case. It's not to discount Lord Diplock's dicta, which is critical, and we see how it's applied in New Zealand. But if you're sitting there thinking, well, couldn't you just explain this case on this basis? The answer is yes, you could. Right, so what we're going to do now is go through three cases where liability is imposed on the defendant for creating or allowing to be created a source of danger where it is foreseeable that third parties may spark it off. And we're looking at three cases here: Haynes and Harwood, McCarthy and Wellington City Council, and Smith and Littlewoods. So, actually, why don't I try and turn this into a slideshow? There we are. So, Haynes and Harwood. A carter left a horse. The facts of this case involved a carter who left a horse-drawn van unattended in a crowded street. Now, this cart was being pulled by 2 horses, and a boy threw a stone at these 2 horses and caused them to bolt. Now, this street that these horses had been left on, untethered, was a crowded street, and it was near schools, and it had been left unattended at a time when schools had just been let out. Schools were closing, lots of people and children were nearby. So these horses bolted, and a policeman stepped in to stop the horses, and this policeman was damaged. So he was injured in the course of trying to stop these horses causing chaos. And it was held that the carter was liable to the policeman for the injury that policeman suffered when he stepped in to stop the horses bolting. The carter was liable for his omission to tether the horses properly. And the court said, look, it is to be anticipated that children will do mischievous things. And anyone who invites or gives an opportunity to mischievous children to do dangerous things cannot escape liability on the ground that he did not do the wrong, but that it was done by mischievous children. So you can't set up something really dangerous and then say, hey, wasn't me who then sparked that off. Okay, the law here, they said, has been... They said the law here is that there is no absolute rule that an intervening act of some third person who is not the defendant is enough to break the chain of causation between the wrongful act and the damage and injury sustained by the plaintiff. Okay, so here the source of danger they created was leaving horses untethered in a crowded street. It was a public place, and they were liable for the injuries caused to the policeman when he tried to avert the danger once it had been foreseeably triggered. And the court said, look, many different things here might have caused the horses to bolt. There might have been a sudden noise nearby or a sudden movement, or it might be the deliberate action of a mischievous boy. But all of these events are examples of the very sort of thing which the defendant ought reasonably to have foreseen and guarded against by taking appropriate precautions and tethering the horse in place. And when you look at cases like this, you can start to think, well, this is these cases are often more act cases. You've created the danger. That's a positive thing that you have done. So if you were to ask the question, would the position be any different if the defendant had not been there? Yes. Why? Because the horse wouldn't have been there either. They kind of brought the danger to the situation. So these are cases where they're not omission cases, but they are cases where you have liability for the act of a third party because you have created a danger that has been foreseeably sparked off by a third party. You are liable. So the next case we're going to cover here is McCarthy and Wellington City Council. I find this case to be a really bizarre case, but we'll go through it. So this is an example of a defendant creating a source of danger on their own land that's then sparked off by a third party. So the Wellington City Council owned a quarry that was within half a mile of Johnsonville and Kandala. Teenagers were known to play in the area. This was pretty material, okay? Now, the Wellington City Council used and stored explosives in the quarry. Detonators were stored in an insecure but locked safe. So a couple of teenagers found this safe and they managed to open it by drawing the rod out of the hinges. Now they then took the detonators out of the safe and they hit them against kind of each other or rocks to try and make them go off, and this was not successful. So they decided that these were harmless cartridges. Now they took them back, one of the teenagers was Wayne Askew, and they took them back to Wayne Askew's home, and they gave these detonators to his 7-year-old brother, Brent. Brent slept with them that night under his pillow. Anyway, luckily for Brent, they didn't go off. The next day, Brent went to his friend's house, detonators in hand. Now, his friend was a 9-year-old boy called Geoffrey McCarthy, of McCarthy and Wellington City Council. So Geoffrey then scratched one of the detonators against a percussion cap he used for his toy pistol. It was obviously some kind of cap gun, and he scratched it against one of the caps. And the detonator exploded, severely injuring his right hand. So this was pre-ACC. So the question here was, did the Wellington City Council owe a duty of care to Geoffrey McCarthy to store the detonators at their quarry securely and make sure they didn't end up in Geoffrey McCarthy's hands? What do you reckon? Oh, I mean, I've kind of answered that question myself, but yes, it was held they owed him a duty of care. So they said, look, the Wellington City Council had created a source of danger on their land by insecure storage of the detonators. And I think this is a little bit surprising because they were locked in a safe, but these guys, they broke into the safe. It wasn't a unbreakable safe. They could just, maybe it wasn't the best safe in the world. But anyway, that was found to be insecure storage of the detonators. And it was reasonably foreseeable that children would play in the quarry area, take the detonators away, and give them to their friends. Okay, and I think it was material here that it was an area that they knew teenagers played in. It wasn't a situation where it was all barricaded up and they made sure no one could get in. They knew people played in the quarry. That was just part of how it was operated. So a duty was owed to all children in neighbouring housing areas, as they were the class of persons likely to be affected by the failure to secure the detonators. Children would take them home and pass them around amongst each other, and injury could happen. Perhaps if this quarry had been in a more remote area, there would be a different outcome where it wasn't known that people played. I think the fact that it was known that children played in this area was significant to the finding of a duty of care. Now we can just compare these cases to the next case that we're going to talk about, where it was essentially found that, we'll compare it and then we'll kind of talk about the comparison afterwards. So this next case is Smith and Littlewood organisation. Now, this involved a cinema, the Regal Cinema in Dunfermline, which was opened in 1931. Now, back in the 1930s, cinemas were grand things. This was very grand. There were 1,800 seats in the cinema. There was a marble staircase. This was a real event to go to the cinema. But by 1976, it had fallen on hard times. And the cinema was sold to the defendant, Littlewoods. Littlewoods planned to redevelop this beautiful cinema into a supermarket. And they employed some contractors to come in and have a look at the building and do some initial kind of investigations and some preliminary work on foundations. But after this initial work had been carried out, the cinema was left empty and unattended by Littlewoods or any of Littlewood's employees. Now, within 2 or 3 weeks, it appeared the cinema was no longer lock fast, and it was being entered regularly by unauthorised persons. School holidays had started, and gangs of local teenagers broke in and turned the cinema into a playground. Now, some were happy with games of cowboys and Indians, others thought that was lame and they were more destructive, tearing radiators off the walls. On one occasion, there were signs of a fire having been started in the lane outside the cinema, with debris from the cinema being used to kind of fuel the fire. So there was also a church next door to the cinema. And one time a church officer who lived next door extinguished a fire he found smouldering inside the cinema itself. So it was very common knowledge in the neighbourhood that the cinema was not lock fast and that it was being frequented by young intruders. But significantly, what could not be proven was that the building's inadequate security had been drawn to the attention of either Littlewoods or the police. Okay, so the fact that Littlewoods, the defendant, the owner of the cinema, did not know about the chaos being caused inside it was a key point in this case. We can compare that to McCarthy and Wellington City Council, where they knew children played in the quarry. Here, Littlewoods had no idea that anyone was playing inside the cinema. Okay, this is one of these legally significant features that distinguish outcomes between cases. Now, on the 5th of July, a fire was started inside the cinema, and it took hold and it caused substantial damage to the properties on either side of the cinema. So one of the properties was the church, and we knew that one of the church wardens had been aware of a fire and put it out earlier in the timeline. And on the other side, there was a kind of cafe billiard saloon. Anyway, this fire was massive. There were 13 fire engines, 70 firemen, and it took them 6 hours to bring the blaze under control. Now, the owners of the church and the cafe/billiard saloon brought a claim against Littlewoods as owner of the cinema, which was the location in which the fire had been started. And so the question that the court were required to consider was, were Littlewoods, as owners and occupiers of the cinema, under a duty to prevent trespassing third parties from causing damage to the plaintiff's properties by the third party's own deliberate wrongdoing inside the cinema? So I think it's useful to put this case into the context of a couple of cases you would have looked at with Simon in relation to liability for damage caused by things on your land. So Sedley Denfield, did you discuss this case? Simon, about the culvert flooding? Yep, I'm seeing some nods. Excellent. Okay, so Sedley Denfield, that case had held that a landowner could be liable in nuisance to a neighbour for damage caused by the landowner's property if they adopted or continued a nuisance on their land, even if that nuisance was put there by a trespasser. Okay, so in that case, I think the council had put some kind of random drainage thing on, and then it had become blocked up, and they knew about the drainage thing on their land, and it caused flooding to the neighbour's property. Knowledge is always quite key in this. and they were held to be liable in nuisance for that act of a trespasser because they had continued the nuisance. And then, of course, there is Goldman, which established that a landowner has a duty to protect neighbours from natural hazards arising on their land. But the issue of liability and negligence for harm to neighbours resulting from acts of trespassers. Okay, so this is different to Sedley-Denfeld because this is liability and negligence. Yes, there's a trespasser involved, but we're looking at liability and negligence now, not nuisance. The issue of liability and negligence for harm to neighbours resulting from acts of trespassers on the defendant's land had not been raised in the House of Lords until this case, Smith and Littlewoods. So there's a sense that all the law lords here were keen to restrict liability of owners for harm caused to neighbouring property by trespassers on their land. And we're going to focus on Lord Gough's judgment because this is the judgment that has been approved and applied in subsequent decisions. You often get these House of Lords judgments where they each get to the same result, but they get there through a different path. And this is the path that Lord Gough took seems to be the one that's been approved in subsequent cases. It's got the most persuasive value. So the short point here is that the owner of the building, Littlewoods, did not owe a duty of care to these neighbouring premises for the acts of the trespassing teenagers on his premises. Now, they recognised that there were some occasions where a defendant would be liable for injuries caused by third parties' deliberate wrongdoing on their land, but foreseeability alone is not enough. Okay, so they actually went through cases where, what are some occasions when a defendant is liable for the deliberate act of a third party? Okay, foreseeability alone is not enough, so what are the occasions where liability has been recognised? And they said, well, one example is when there has been an assumption of responsibility by the defendant. And an example of this is Stansby and Troman, which we talked about yesterday. The decorator left alone on the premises by a householder was held liable when he left the premises and didn't lock the door, and the thief entered and stole the necklace. Okay, so in that case, the decorator had assumed responsibility, and that was enough to make the decorator liable for the deliberate wrongdoing of a third party. Then they talked about what a duty might arise when there is a special relationship between the defendant and the third party, where the defendant is responsible for controlling that third party. And an example of that is Home Office in Dorset, okay, when they had that responsibility to control the Borstal boys and that specific particular risk to those plaintiffs. And another example they said is, well, when a defendant creates a source of danger and it's reasonably foreseeable that a third party may interfere and spark it off, causing damage to people in the position of the plaintiff. The example they gave here was Haynes and Harwood, where they created the danger by leaving the horse in the street, and it was sparked off by the mischievous boy. They were liable for the injury caused by the horse. And they said, but actually there are two key differences between the facts of this case and the facts of Haynes and Harwood. And this is where you see this great analogical reasoning. Why is there liability? Why was there a duty in that case? And why isn't there a duty in this case? And what is the key difference between it? Because that's the stuff that you use in novel situations to work out which way the law is likely to go. Okay, and here they said, well, look, Haynes and Haywood involved the creation of a source of danger. An empty building alone is not a source of danger. Okay, so that was one of the key differences between Smith and Littlewood, and Haynes and Harwood. And the second difference, they said, is that Haynes and Harwood involved the creation of a source of danger in a public place. Here, the third parties created the source of danger themselves when they lit the fire, and they were trespassing on the defendant's private property when they did so. So they said that the factors that justified the duty of care being imposed in Haynes and Harwood for the act of a third party couldn't justify a duty in this case. So then the next question they asked was, well, should the owner be liable for a fire started by a third party trespasser when he had no knowledge that the third parties were trespassing? Should the law expand here? We can't find a duty on the basis of Haynes and Harwood, but should we find a duty nevertheless? Should we expand the law here to find a duty of care? Should the owner be liable for a fire started by a third party trespasser when he had no knowledge that the third parties were trespassing? And they said, look, maybe there would be an argument if the defendant negligently caused or permitted the creation of a source of danger on land when it's foreseeable that a trespasser might come in and spark it off. And the example they gave was this kind of hypothetical example. When they said, look, let's say there's some kind of village, and every year there's a big fireworks display in this village. And every year there is a certain person who is asked to buy a substantial quantity of fireworks. And every year he does this, and every year he stores them in an unlocked garden shed that abuts onto a neighbouring house. And it's well known that this is where the fireworks are stored the night before the big fireworks display. Okay, the village all know this. The fireworks are in the shed over here. And then mischievous boys or mischievous girls enter as trespassers and light the fireworks. And this causes a serious fire, which then burns down the neighbouring house. They said, well, liability might well be imposed in a case like that for the acts of trespassers on private property, given the dangerous and tempting nature of the fireworks. You know, interference by naughty children is the very thing, they said, in that sort of case which the storer of those fireworks ought to guard against. You know, they should don't create the temptation, lock the shed, make sure it's secure. Now, this was all obiter, but that was an example of when they felt that liability might exist for the acts of a trespasser. But here they said an empty building is not properly described as an unusual danger in the nature of a fire hazard. It's literally just an empty building. It's not like fireworks, okay? There's nothing about it that suggests it could easily be set alight. There isn't the same temptation with an empty building as there is with a garage filled with fireworks. So they came up with this hypothetical situation and then they distinguished it from that. And then they looked at the Goldman duty. And they looked at what justified the Goldman duty, where an occupier of land is liable for the spread of a natural hazard from that land. And they said, but key to the Goldman duty is that the occupier of land has knowledge or means of knowledge of the hazard. Okay, and in this case, they said, well, a defendant might well be liable for damage caused to neighbouring property by a fire started by trespassers if they had knowledge or means of knowledge that a third party is entering their property and has created or is creating a risk of fire or has started a fire. Okay, if they've got knowledge that this is happening, they might well be liable. And if they have knowledge that this is happening, they would have to take those reasonable Goldman steps, okay, which are subjective steps depending on the means and ability of the occupier. So things like that might include informing the police or securing the cinema or warning neighbours and inviting their assistance. Or if it was a very large public company that owned the building, they might be expected to employ an agency to keep watch over it. But here, the evidence showed that Littlewoods had no knowledge or means of knowledge that children were entering into the building and lighting fires. Okay, they didn't know either of these things. Nobody told them. There was a notice outside the building that had their details on it. You know, that essentially said, building owned by Littlewoods, this is our phone number, should any issues arise. Nobody called that number. Nobody told them. Okay, so the occurrences of the fires had never been reported to Littlewoods and had never been reported to the police. Without being told about the fact that fires had in the past been lit in the building, that intruders were entering in the building and generally causing chaos, empty buildings themselves are not likely to create a risk of fire. So they concluded that no duty of care was owed. The general rule is that there is no general duty of care on owners and occupiers of land to prevent third parties using their land to cause damage to others, but a duty might be owed by an owner-occupier for a danger on their land sparked off by a third party if the defendant negligently creates the source of danger. So an example would be that fireworks situation, keeping a whole lot of fireworks in an unlocked shed, or where the defendant has knowledge or means of knowledge that a defendant is creating a danger on their land, that a third party is creating a danger on their land and they fail to take reasonable steps to abate it. So, any questions about Smith and Littlewood? It's one of the more significant cases in this. So, in summary, key thing, think about the difference between making things worse and failure to confer a benefit. We have a duty to exercise care in our actions, in our positive actions, which may cause foreseeable harm to others. I've mentioned that this can include the interference principle arising out of Tyndall. We will come to that very shortly in our public bodies lectures. Okay, so actions, we have a duty of care that's quite straightforward. Omissions or acts of third party. When is a defendant going to be liable for their omission or for the immediate wrongdoing of a third party? The general rule, defendants are not normally liable for dangers they have not created unless special circumstances exist. What are those special circumstances? First, when the defendant has assumed responsibility by taking on a task for the claimant's welfare. And there are examples of cases we've discussed there. Second, defendant's status is holding a position of responsibility. Goldman's an example. I would say that Barrett and Ministry of Defence would be another example there, where as the employer. Third, defendant's in a position of control over the cause of danger, and there's reasonable foreseeability of harm caused by that danger, and there's particular risk of harm to the particular plaintiff. Home Office endorse it. We are likely liable for dangers we have created, including when that is sparked off by a third party, where it's foreseeable that third parties might spark it off. Haynes and Harwood, McCarthy and Wellington are examples where liability was found on that basis. Okay, so that is what we're going to now move on to. I'll just bring up the slides, is public authority liability. And the reason we do it like this is public bodies are often caught up in these cases. You know, even just looking at these cases here, Kent and Griffiths and London Ambulance. Well, London Ambulance was a public body. Chelsea and Kensington, that was a public body. Ministry of Defence, that was a public body. Home Office, that's a public body. Wellington City Council, that's a public body, okay? So a lot of the cases involving omissions involve public bodies. So we've got our general framework of when liability will be imposed, and now we're going to see what does the kind of inquiry look like when a public body is involved? But I will just bring up the slides. You can talk amongst yourselves for a minute or so while I do this. Okay, so first question, what do we mean by a public body? Do you want to just give me some examples of what a public body is? Shout them out. Yes, councils, excellent, thank you. Anyone else? Just think of any kind of public body. Are the police a public body? Yep, I'm seeing some nods. Social welfare, is that a public body? Yep. Okay, the probationary service, public body. Government ministries, any kind of government body is a public body. Fire services, ambulance services, councils, local authorities, all of these things are public bodies. Okay, and the thing about public bodies, the thing that distinguishes a public body from a private body is that public bodies exist to serve us all. Okay, and you know, the police are there to suppress crime. Probationary service is there to monitor criminals who are released back into society. Oranga Tamariki's function is to protect children from harm. Local councils are there to do a whole lot of things for us, to fix our water, to sort out our roads and do other things. Okay, so if the public body is careless in carrying out their duty and crime isn't suppressed, or a criminal is released into probation and not monitored properly and then they cause atrocities, or social welfare carry out a really careless investigation into a child and that child is then left in a situation where they're abused, then there's a sense that the public body should be liable. Now, the thing about a public body is that they exist to serve us all. They have a specific job. They have a statutory duty or a statutory power to do the thing. Okay, and if they haven't done it and someone suffers harm as a result, they haven't done it properly and someone suffers harm as a result, there's a sense that they should be liable. But that's not quite how it works. Okay, the key message is just because a public body has a statutory duty or a statutory power to do something, that is not a shortcut to common law liability, to private law liability to an individual. To be successful in a private law claim in negligence against a public body, it's necessary for the claimant to prove that that public body owed the claimant individually a duty of care in providing the public service. Okay, it's necessary to show that that public body owed the plaintiff individually a duty of care, for example, in policing crime, in monitoring probation, in placing them into care. Okay? It's very difficult to do this. Just because, for example, the police have a statutory power or duty to suppress crime does not mean they are on the hook to a victim when crime is not suppressed, when it could have been had they taken reasonable care. The statutory duty can't be used to make that link. You need to establish it in the normal way that you would have to establish it as against a private body. Now, often claims against public bodies are claims for omissions, or they are claims for the direct wrongdoing of a third party. So they're the sorts of cases that we've just been talking about today and yesterday. Okay, so it might have a crime committed by a criminal, but the plaintiff sues the police for failing to prevent it. Or the fire service come to a fire and they fail to put it out properly, and that causes the neighbour's house to burn down. Many of the claims against public bodies involve a public body who has somehow failed to confer a benefit on the plaintiff. So all the ideas we've looked at in relation to omissions and third-party interventions frequently arise in claims against public bodies. But like I said, a duty to take action, a duty to confer a benefit, or a duty in relation to preventing the acts of a third party needs to be established in the same way that it's established against a private person who doesn't have these extra powers. And in addition, there are these extra steps that need to be taken into account. So, when we're dealing with public bodies, the courts are very careful not to overstep their role. It's that kind of separation of powers. And so they can't get involved in discretionary policy choices of public authorities in a private law claim. Okay, public law does its own thing, but in a private law claim where you've got a private party alleging negligence against a public body, the court cannot get involved in a policy choice made by that public body. They can't second guess choices made by that public body about how that public body might allocate what are often very restricted resources. Courts are really conscious of this, and it means there's this extra step involved in a claim against a public body, which is justiciability, and we'll come to this, okay? But it's this question of, is the claim justiciable? Is this something the court can get involved in? And there's also this balancing of two impulses. So on the one hand, a court wants to protect public authorities and public bodies from excessive litigation and threats of liability that might have a chilling effect on how it carries out its role, and this chilling effect would not be in the public interest. But on the other hand, they want to make sure that deserving individuals who've been harmed by serious failures on the part of public authorities don't find themselves uncompensated. So these two impulses pull the courts in different directions in a way that a claim against a private party would not. The court's not so worried about a chilling effect on a private party because as private bodies, we do what we want to do for our own interests. Public bodies act in the interests of all of us. So if there is a chilling effect, if there is excessive liability, then there's the sense that what's known as a tort tax, which is when Any compensation the public body has to pay is paid for by all of us in the form of taxes and rates, etc. And it's money that comes out of the same budget that would otherwise be used to provide the public service that benefits all of us. So this is something that exists in a claim against public bodies that doesn't exist in claims against private individuals or private bodies. So this means we get these additional policy concerns that can come up in our external inquiries about should a duty of care be recognised in a claim against a public body or not. These are the external inquiries that we'll find come up in a public body context which don't arise in claims against private parties. So, how are we going to cover this area is... First, we're going to look at a general framework for dealing with duty issues in private law claims and negligence against public bodies. I think it's useful to be able to structure your thought process in a certain way, and this is a way that we see courts doing this, so we'll go through this framework. It's not a straitjacket. Things can be considered, and we'll talk about that. Then we're going to look at 4 cases involving a claim against a public body where there is no third-party wrongdoer involved. And then we're going to look at about 8 cases where the immediate wrongful act was carried out by a third party, but the claim is brought against a public body. And these cases will cover claims against the police, the probationary service, Ministry of Agriculture and Fisheries, and social welfare. And at the end, we'll just have a bit of a think about some big picture questions. Okay, so the framework. First question is the matter justiciable? This involves looking at whether the alleged negligence occurred in the exercise of a statutory discretion involving a policy consideration. If so, the courts they're not going to get involved. Okay, it will be regarded as non-justiciable in a private law claim. We will come, that should be number 2 there. I don't know why it says number 3. We'll come back to this on Tuesday because it's 9:55 and we'll go through it then.